They know.
You know what? I did worse. I stepped out of my ideas. If you no, I would say that was the reason it was like sat there. Because that window, you do it. All too well.
You know what I'm saying? No. Salad.
It's really had a problem with that first line address. I just think it's inconsistent with the jury's verdict. But I told her, I said, you gotta stay on.
Yeah. Julie expected an extra day of benefit.
That's what they call it, what do they call it, constant holiday?
first day of retirement. I don't think the answer's I'm just going to show up for work anyway. Get a trespass warning from the state.
Never. Standing invitation.
Yeah.
They're cool. They're putting away the coffee, but
I know.
they're not playing games.
I
I
know.
drink it. I just don't drink it.
Me neither. I try not to.
Kind of stick in water or something and I can hide it. It's just I'm not saying that. I just think it's
You should hide it.
I feel like, and we've been, I feel like I'm certain personas that are trying to keep in here. The jury, because I think they have expectations of us that they don't necessarily go with you. And we need to meet those expectations. Like,
That's
you
true.
have a customer service view of prosecution.
Oh yeah, you
Yeah.
should. You should.
Because I think they judge us in the real moment. And I think they need to think, why do I do this? I think they need to
You're right. You're right. For me, I'm telling you, parents is everything.
yeah, man. It really is.
Court come back to order.
Yeah,
You see it?
Mr. Knock, are you ready to go?
Yes, Your Honor, I think we have one thing to discuss before I do.
Okay.
Yes, Your Honor. The defense provided me just a moment ago with this list of mitigating circumstances. I do have an objection to one thing on it. I get
Okay.
the second sentence of the first numbered paragraph, I would submit violates the prohibition of arguing residual doubt. Saying there's no evidence he was there. The defendant, the jury by their verdict, has already found him guilty of burglary, of entering or remaining in the home, which is completely contrary to that statement. I just got this. I don't know if the court's familiar with the case law on residual doubt, but there's ample case law which indicates that the defense is not permitted in penalty phase to argue residual doubt from the guilt phase. And as far as firing the shots go, the jury's verdict didn't make a specific finding of that. He can argue that that's acceptable. But the second sentence is an argument of residual doubt, because there was no theory of prosecution where the defendant was not present in the home. That's the only evidence there was, and the jury accepted it, and that issue is over.
Response.
Judge, the state argued the principal theory in this case. They argued that he could be convicted just by virtue of his planning. The principal instruction that was given to them permits them to convict a person who is not present when the crime is committed. Furthermore, the state objected in court refused to do a special verdict form so that we would know what their verdict is. I can tell the court I absolutely do not intend to argue that he might not be guilty. I'm going to concede that I'm not disputing that they found him guilty, and specifically that the evidence shows that he was not the shooter and not based on the description. Certainly, in fact, counsel
Well, if it-
said, argued about that penalty is for those who are actual killers. I think he said our planners.
If the defense in the context of this is going to admit that he planned the home invasion and the murders, I'll withdraw my objection. But for that, this is residual doubt.
Well, the problem is the count that they found him first-degree murder was not, for lack of a better term, an itemized verdict form, and it could have been premeditated, it could have been felony,
Sure.
and the principal was one of the instructions given in this matter. they cannot argue residual doubt, but I think you made a statement, I believe, Mr. Ashton, in your closing, this was the individual who fired the shot
Correct.
In the house. And I think they can argue that, well, he may be guilty, he wasn't the one that did that. So.
No, I don't have an objection to that part. It's only the second sentence. The first part, he didn't shoot, no objection, that's fine. It's the second part that just to be clear, it's
But
only the second part.
he could have been found guilty of the charge even if he wasn't in the house, could he not, by the jury?
Not based on any set of facts that I know of. But you...
Under the felony murder?
But not burglary.
No, under not, okay,
Judge,
I'm going to allow it.
what do you want to do?
I'm going to
I
allow
just
it.
want to make the
Okay,
objection.
thank you, and I appreciate that, thank you. Which goes back to the other question, are you ready?
Yes, if I can help my,
No. Is the machine set up?
It is, and it appears to be.
Mr. Williams, our expert, is here, so.
I checked it myself.
Okay.
Which
So,
means I may be wrong.
what I'm going to do, just so you know, Mr. Ashton and Mr. Naku, when you finish yours, I'm going to send the jury out for a brief break, give them menus, have them fill them out, bring them back in, give them the instructions, and then we'll send them out to deliberate. Okay? Go ahead and bring them in, please. If they're ready. If they need more time, that's fine. Mr. Naku, are you using the remote mic?
No, not at all.
You don't want-
Speak up.
Okay. Okay. This courtroom takes care of everybody differently. Mr. Ashton, have you taken your mic off?
I already had, so.
You're welcome to be seated. We have a juror in the restroom for a moment. He'll announce it when they come in.
All right, jury dinner.
Please be seated. Mr. Naku, closing for the defense.
Good morning, folks. I'm usually very comfortable in a courtroom, but this is maybe the only exception, and I think it's just because what we're doing today is so important. The job that you have today is hopefully the hardest decision you'll ever have to make. I'm going to talk to you about a few things. I'm going to talk to you a little bit about the jury instructions. I'm going to talk to you a little bit about the aggravating circumstances. And I'm going to talk to you a little bit about the mitigating circumstances. One thing I want to point out, and I'm sure you know that now the judge will give you a full set of instructions before you go back to deliberate. There's one major difference between this deliberation and the deliberation that occurs in the guilt innocence phase, which is that your decision does not have to be unanimous. You should certainly discuss the evidence with each other, talk about the pros and cons of your position and their positions, but when all is said and done, each of you must individually make your own decision and recommendation to the court. And as you know, it is a recommendation. The court will impose the final sentence, but as you've heard already, and I think it really is something you need to consider yourselves as deciding the fate. You can't pass the buck. You shouldn't want to pass the buck. You all are invested in that. You've been here a very long time. You've heard some very difficult evidence. And now you make your decision. I'm going to talk a little about the aggravating circumstances. The state has already explained to you what aggravating circumstances they think they've proven. What I want to talk about has more to do with the weight. And I got to tell you, this is probably the toughest part of not only the arguments, but the decision-making process. It is unpleasant. There is no way around it. When weighing the aggravating circumstances, you're not comparing what happened in this case to the way that people normally treat each other. Every first-degree murder is a terrible crime. Every single one. Because it means that a person was killed for no legal or moral reason. They are all indefensible. So when you're deciding whether this crime is particularly heinous, atrocious, and cruel, for instance, you're not comparing it to the way people normally treat each other. You have to compare it to other first-degree murders. You have to imagine other circumstances. And the prosecutor touched on it a little bit, but I think it's important to go into a little bit more depth. And if it sounds callous, I apologize. What happened to Alex Zaldivar is a terrible thing. I never said otherwise, or something. But the fact remains, he died a quick and painless death. And that doesn't make it a good death, certainly. I'm not saying that. But it means it was not especially heinous, atrocious, cruel. He was not choked to death. He had to stab to death. It was not a rape, murder, or something like that. It was a murder. It was terrible. It was not especially heinous, atrocious, or cruel. Remember that what you were deciding is, and this is how it's often put, death penalty is reserved for the most aggravated, least mitigated of all first-degree murders, not of all crimes, not of all things that we do to each other. The most aggravated first-degree murders, and you have to have this unpleasant weighing process when you decide, compared to other first-degree murders, is this one especially heinous, atrocious, or cruel. Probably the best part of the instruction that tells you that it isn't is the cruel instruction. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. That gives you an idea of what that aggravating circumstance means. This crime was not especially heinous or cruel. It was a terrible murder, as all murders are. It was not especially heinous or cruel. The other aggravating factors, I want to talk more about the weight. Counsel pointed out that the crime was committed to either a government function or avoiding lawful arrest or escape, and admitted to those go through the same factors. It was, according to their evidence, for the elimination of the witness. I suppose not every murder, but most murders are committed for a reason. And again, you have to think about what are the possible reasons for first-degree murders. People kill greedy, money, some kill for notoriety, that's fairly rare. Some kill out of jealousy. There's always a reason. None of them are good. The reason here was to eliminate the witness. It's not good. None of the reasons are good. If a person was killed in self-defense, it would not be first-degree murder. So in deciding how much weight to give that aggravating circumstances, I ask that you bear that in mind. Evidence, yes, that was the reason for this crime, but every first-degree murder, most every first-degree murder has a reason. I suggest that that is not one that you should give especially serious weight. It is simply the reason that the evidence showed this crime was committed. It will be entirely up to you to decide how much weight. There's no number scale. You simply decide, compared to other first-degree murders, is the aggravation in this case of such a weight that it is among the worst of the worst, or you have to impose death. I would submit to you that it is not. Now I want to talk to you about the mitigating circumstances. As you'll be instructed, the mitigating circumstances are different. You know, we talked about this many times in the past 3 weeks. There are specific aggravating circumstances you can consider. You can consider anything mitigating that's presented to you by the evidence that you personally find mitigating. There's no set list. I have identified 26. You might find there's some overlap in them. You might find only 20 or 20, whatever. One of the instructions you'll get is it's not a counting process. In fact, there's more mitigating circumstances. Does not mean they are more weighty. You weigh the quality of the evidence, not just the quantity of it. Another bit of a difference is aggravating circumstances have to be proven to you beyond any reasonable doubt. Mitigating circumstances you can consider if they are reasonably established as true. And again, you get instructions on that. Let me talk to you about the first 5 that I use is in no particular order.
Objection, Your Honor. Could we approach? I think there's been a mistake.
Please approach. Folks, there was a comment made a moment ago about the weight or the what must be proven, the burden. I'm going to give you instructions later on, but to help in this matter, I want to remind you that a mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proved by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. Any statement made to the contrary should be disregarded. Please proceed.
Okay, thank you. I was paraphrasing, but as I said, you should rely on the written instructions the court will give you within time. Let me talk to you a little bit about the first 5 mitigators I have listed. And I'll tell you right up front, some of you may not agree with the first one I have listed. I am not here to argue that your verdict was wrong. You thought long and hard about it and you listened to the evidence. But among the things you listened to was a description by Brianna Campos of the person who brought her out of her room and who she believed fired the shots, and her description, by her own admission, did not match Bessman Okafor. You certainly were presented with other evidence from several sources that he was involved in the planning and had a motive, but the fact remains that Brianna Campos said that the person who brought her out of the room and who she thinks fired the shots was tall and lanky and had different hair than Bessman Okafor. She told you that herself, and there was no other evidence to contradict that statement. None. Now, I submit to you that that is a mitigating circumstance, and perhaps the most weighty of the mitigating circumstances. Another thing that is really hard to ignore is that, again, according to Brianna Campos, that person said to her, "Is this the house where the robbery happened?" That is a very important statement. Is this the house where the robbery happened? If that were Mr. Okafor, based on the evidence the state provided, would he have asked that question? No, he wouldn't. I would submit to you that that mitigating circumstance is proven. You each must decide that for yourselves. The second and third, state has mentioned already, Emmanuel Wallace and Donnell Godfrey were convicted of first-degree murder and were sentenced to life. You know they were both in the house. Based on the evidence, you know they were. And you know they had guns, and you know they were involved. And they received a life sentence in this case. And that, I submit to you, is a mitigating circumstance that you should consider. 4 and 5, Sharia Gordon and Nestle Cicerone. Those are the 2 witnesses who testified, and they explained to you that they made deals with the state, that they had at one point been charged with first-degree murder. The state argued to you that they had the evidence to convict them of first-degree murder. They made deals, and we don't know what they will be sentenced to. They haven't been sentenced yet, but they will receive a term of years. They will receive a length of a sentence, and then they will get out. And I would submit to you that those are also mitigating circumstances that you should consider. Now let's talk about Bessman Okafor's background. The state has suggested that
none of what we presented about his childhood has anything to do with anything and shouldn't be given any weight by you. But you know that a mitigating circumstance does not have to be connected factually to the crime to be considered by you. And it was no surprise that the state argued that the evidence about Bessman Okafor's paternal family was equivalent to his 5th grade medal, but I submit to you it was not. Ask yourselves if Bessman Okafor had grown up with his father Charles, or his aunt Eucaria, or his grandfather James Okafor, would you be sitting here today? Would we be sitting here today? I would submit to you that we would not. It was suggested that the grandfather in particular was completely unimportant because he'd never even met Mr. Okafor. And I hope you understood the point. This is a 95-year-old man who traveled literally halfway around the world to testify for 10 minutes about a grandson he never even met. Would Carolyn Ruffin have traveled halfway around the world to help a son even if she had never met? That's why that's important. That's why Eucaria Okafor is important. He had a paternal family that family meant so much to, that if he had grown up with them, the significant things would have been entirely different. And that is important. That is an aggravating circumstance that I ask you to consider. Marcia P. was not even related to Bessman Okafor. And yet she took him in and helped him. And do you have any doubt that she would have raised him if she were allowed to do so? And raised him certainly much better than he was raised. You know from Dr. Taylor that Bessman Okafor was born with a learning disability. He had difficulty processing language. And the doctor explained to you that that causes problems with education, and it makes sense. You know, sometimes the experts, they tell us things that we instinctively know already. But he is an expert. He's been doing it for 30 years. He examined the records that he normally examines, even with his clinical patients. It's been suggested to you that because he didn't talk to teachers 10 or 15 years after the fact, that you should ignore what he said. What he used instead were contemporaneous records, the records they wrote down at the time. What's more reliable? What the teachers are writing down at the time, or what they might remember 15, even 20 years later, 25 years later? The records. And he explained that to you. The records were important. And the records show that he did not get treatment for that learning disability. And I'm not knocking teachers. I love teachers. They're amazing people. But the fact remains that Bessman Okafor did not get treatment for a learning disability that he was born with that made it difficult for him to get by in school. Because he didn't understand what was being said. He wasn't able to communicate effectively. It also caused him to act out, and that makes sense too. Somebody who can't use their words properly acts out in other ways. And that is a mitigating circumstance that you should consider. I would also point out a little bit, there was some suggestion that maybe Marcia was making up for embellishing what she told you about Bessman Okafor when he was put on your doorstep. That he may have been younger than she was saying. And there was some confusion about the dates, but what she wasn't confused about was that he was older than her son Charles had already been born. That Bessman was 3 years older than Charles, was old enough that he should have known his alphabet and should have been potty trained. And he was not. And remember, she was a special ed teacher, so she would know. She showed you, or told you, that this photo depicts her and Bessman at about the time she got him. And that is certainly a child who is old enough that he should have been potty trained and known his letters. And remember how she described that. He was dumped off at her mother's doorstep with a bag full of underwear. She didn't understand it at the time, but later found a bunch of soiled underwear hidden in his closet. Now, do you really think she's clever enough to have just made that up? Perhaps, but I doubt it. This photo speaks volumes. This is his bedroom that she was setting up for him when he first arrived. And you can tell again from that photo, it's a child that should have been potty trained, should have known his letters by then. The mattress on the wall shows, yeah, it was the room just being set up, and you can see the letters in the background that she put up on the wall to help him. Do you think he got any of that at his home back here in Orlando? There's certainly no evidence of that. This is Bessman Okafor as he could have been if he had been raised in a loving, helpful home. I submit to you that is something you should consider mitigation. And yes, it is not the weightiest of the mitigation in this case, but I ask you not to dismiss it the way the state has. Because it is important, it is truthful, it is supported by the evidence. So instead of being raised by Charles, because of his death, or Marcia, even after that, he was, after first being abandoned on a stranger's doorstep, he was then kept away from his paternal family. Remember the testimony where Catalina Ruffin told Bessman after the funeral of his father to give Marcia a hug because he's never going to see her again. Number 11, he grew up with 4 role models. That is a mitigating circumstance that I submit to you is very important. Not only did he grow up with 4 role models, he had not a single good role model. His mother, she candidly admitted to you about the terrible conditions that existed in her home, the violence, the men she was with and their violence. And so we're clear. Akpan James was the one she testified was a terrible alcoholic. And it was his alcohol-fueled rages that caused their fighting. Mr. Trevor Sinclair, and not an important point, but I still have to make it. Trent wasn't lying when he initially said he didn't have a drinking problem. He didn't.
Objection to counsel's expression of his opinion on the truthfulness of a witness.
Overruled, because it's not an opinion he's giving. He's giving statement of what he heard.
He didn't see having a beer in one's hand all the time as a drinking problem. Certainly in his home, compared to acting on James, that would have been a big drinking problem. Bessman Okafor suffered regular bullying in school. They didn't have the right clothes. They had holes in their shoes and were constantly bullied by the other kids. And again, not in and of itself the weightiest of mitigating circumstances, but I would ask you to consider it. And I'll talk a little bit later about why some of these circumstances come together and paint an important picture. I already mentioned he moved homes and schools often. Certainly that did not help with his learning disability and with his inability to cope in school. Lack of psychological care and treatment. He was physically abused by his mother. He was not simply spanked or punished. It was not the kind of punishment she received from her mother. He was stood up against the wall, stripped naked, and whipped with a belt buckle or an extension cord. He suffered scars. It was so severe that his mother was arrested, taken away, charged and convicted of aggravated child abuse. This was not punishment. This was torture. She went to parenting classes as part of her sentence, but said she got nothing out of it, because that's just the way they were teaching isn't the way she did things. He was sexually abused at 14. He did not get treatment. The state attorney's office offered him treatment, offered his mother treatment. She didn't get it for him. And why? Because he didn't want it. He was 14. It was up to her and them to get it for him. He did not get any treatment. Treatment is offered to the victims of sex abuse for a reason, because it's necessary. He was treated differently from his siblings. Trent and James talked to you a little bit about that. And I would submit to you that you can believe every word that Trent and James told you. He was not comfortable airing these early on here. You can tell that from listening to him, but he did. And he candidly admitted about the drinking and the beatings, and Bessman got it the worst of all of them. And Bessman was virtually ignored by the men in his mother's lives. Like he wasn't even there. We'll talk a little bit more about the ACEs, the adverse childhood experiences. But as Dr. Gold told you, they result in anxiety, aggression, and poor impulse control. Those were the manifestations in Bessman Okafor. Different people have different outcomes. Those were the problems that resulted in him from what happened to him as a child. And that is a mitigating circumstance to consider. And he suffered the loss of his young son and his daughter. And that is a mitigating circumstance that you should consider. I want to talk to you a little more about the adverse childhood experiences. As I said earlier, in a way, experts often tell us things that we instinctively know. Any of you who are parents know that the way you bring up your children is important. You don't need an expert to tell you that. Parents revel in their children's accomplishments because they know that they're in part responsible for them. They suffer with their children and their failures because they know they're in part responsible for them. And yes, not every family is perfect. Families are perfect. But Bessman Okafor's upbringing was absolutely horrendous. You recognize, these are the, what's labeled 18 to 26, you recognize those as the adverse childhood experiences that the doctor mentioned, but there are also things that you know instinctively are important. Losing a parent, especially to death, is going to adversely affect a child. Physical abuse, certainly, is going to affect a child. Verbal and emotional abuse is going to affect a child. Sexual abuse. Emotional neglect, simply being ignored. That makes the place you come home to every night something other than a home. When you go there and the man sitting in the parking lounger ignores you. Physical neglect. Being hungry because there isn't enough food in the house. Domestic violence. Regularly watching the only adults that you have contact with on a regular basis beating on each other. Yelling and screaming, not just once, not just occasionally, but over and over and over again, is going to have adverse consequences. Having a household member incarcerated, it wasn't just one, and it wasn't just, oh, she was brought up and down. She was arrested for abusing him and taken to jail, and then ordered for a time to not even be allowed around the family. And you don't need Dr. Gold to tell you that's going to have adverse consequences. Now, and that's not to say his testimony wasn't important, because it was. What he does is kind of put it in perspective for us. Remember, one of the things he said is that one of these studies of 165,000 people, I think he said, showed that 60% of kids had none of these adverse consequences. The prosecutor mentioned, well, everybody has bad things in their past. And sure, that's true. But 60% of kids have none of these. We said that the scale they usually use is they look at whether someone has 1, 2, 3, or 4. 9 is off the charts. He told you that 9 virtually guarantees an unsuccessful outcome. Virtually, Bessman Okafor was doomed by his upbringing. And as has been pointed out, I never said that that is the reason this crime happened. I didn't ask Dr. Gold to determine that, and he admitted he could not. It causes different kinds of harm to different people. But what is certain is that it causes harm. Serious, long-lasting harm. The initial study of 17,000 people. They were in their 50s, and they were still suffering from the consequences of their upbringing. And Bessman Okafor's was off the charts bad. Imagine what it was like growing up as he grew up. Once
Objection, Your Honor, golden rule violation.
Sustained. Jury will disregard. Restate.
Think about what it must have been like in Bessman Okafor's home as he was growing once he got back here to County home is supposed to be where you're safe. But his home was nonstop violence. He would come home every day wondering whether her mother's boyfriend or husband was going to be beating on her, whether she was going to be fighting back, whether there was going to be yelling or screaming. He was wondering whether he was going to get hit, and if so, would it be an extension cord, a belt? If it's a belt, probably wondering, geez, I hope it's the end with the holes in it and not the buckle end. Wondering whether he was going to be stripped naked and put against the wall first. That was what he grew up to. He would wake up in the morning wondering if he was going to be able to eat that day. Some kids with homes like that have school as a refuge, but he wasn't successful in school because he didn't understand what they were saying, and he wasn't able to communicate effectively back. He was bullied by the other kids because of his clothes and his shoes. So school wasn't safe for him. He had no father to take him to the field, ball field, and play catch with. He did the things that most people expect. And then, when he was 9, the police actually got involved and took his mother away because she beat him so badly that it left scars on him. Aggravated child abuse, and she went to jail for it. Was that a good day or a bad day? Who knows? It was his mother. And then she was allowed back in the home. She took parenting classes that apparently were no good by her own admission. Somebody allowed her back in the home. And I believe you'll recall her testimony was that this fighting that occurred between her and Mr. James or Mr. Sinclair was a regular occurrence. Worse with Mr. James because he was apparently a really mean drunk. He's 14 years old, in the middle of the night. A 33-year-old man is in his bedroom sexually abusing him. And not for the first time. It's been suggested that maybe it wasn't too terrible because there was no force.
Objection, Your Honor. May we approach?
You may. Objection is sustained. The jury will disregard the last remark.
At 14, Bessman Okafor was molested repeatedly by a 33-year-old man. His mother did not get counseling for him, did not want this man to go to jail, because she was friends with his fiancée. That's the kind of home that Bessman Okafor grew up in. Now, don't misunderstand me. I'm not making excuses. The only two options now for Bessman Okafor are life in prison or death. He is not going to be released, ever. He is never going to have any kind of a home again, good or bad or terrible. He's going to be living in a prison, a metal box. He's going to be told when to get up in the morning, when to go to bed at night.
Objection, Your Honor, outside the evidence.
Reasonable.
It is reasonable. Overruled.
When to go to bed at night, when to eat, what to eat. He's going to have the same view out the same window of the same barbed wire.
Objection, outside the evidence.
Okay. We are getting a little strained far now. Staying at that point.
He is going to be punished. He is going to be locked up forever until he's taken away in a fine box. All I am arguing to you is that this is not the worst of the worst. This is not a case that's so aggravated, with so little mitigation, that you must impose the death penalty. If Bessman Okafor had been a well-adjusted man, if he had grown up with Marcia or Euteria or Charles had lived, and none of these terrible things that happened to him did not happen, that would be an entirely different story. Adults make choices based upon the things they know, the way they think, the upbringing they have. Bessman Okafor grew up in an environment of violence, of terror. He grew up in an environment with no safe place. He wasn't safe at school. He wasn't safe at home. He wasn't safe in his own bedroom. Is it really any wonder that he's sitting here today? And I'm sure some of you are thinking, well, he's made his choices. And counsel for the state has told you, well, yeah, he had a terrible upbringing, but he's an adult now. You can't ignore the connection between the two. The way a person's brought up is what makes them who they are. Bessman Okafor did not choose to be abused. He did not choose to be hit with a metal belt buckle until he scarred. He did not choose to witness his mother and her husbands or boyfriends physically beating each other up and yelling at each other day after day. He did not choose to go hungry. He did not choose to go to school in shabby clothes. He did not choose to have a learning disability that kept him from doing well in school. He did not choose any of those things. But all of those things affected who he is now. That is mitigation, it's weighty mitigation. It is why this is not a case of murder that is so aggravated, so little mitigation, that you must invoke that point. It is just the opposite. He grew up in unimaginable, horrible, terrible circumstances. And there's nothing that can be done about that now. There's plenty that could have been done at the time, but there's nothing that can be done about that now. But what you can do is return a lawful, just verdict of life in prison. I'm not going to ask you to ignore the weighing process. I'm asking you to use the weighing process to find that because of these circumstances you grew up with, the mitigation does far outweigh the state's aggravation. Justice in this case means a life sentence without possibility of parole. That's justice in this case.
Thank you. Ladies and gentlemen, I'm going to give you a short break, about a 5-minute break. When you come back in, I'm going to give you the instructions on this case, give you copies of those instructions, and send you back to deliberate. What we're going to do is, while you go back for this short break now, we're going to give you the menus to order lunch, because we'll have that available for you when you're back there deliberating. Please do not discuss the case amongst yourselves. Do not discuss it with anyone else. You still have to hear the law on this matter. Please leave your pads on your chairs. We'll see you in about 5 to 10 minutes.
All right, thank you.
Be in recess for about 5 to 10 minutes.
Thank you.